Hi, everybody. I think we're live now. Welcome. Welcome to the next in our series of myth busting, legal myth busting webinars. Today, we're going to be talking about at work, busting legal myths about your rights on the job. I want to acknowledge that the Center for Public Legal Education, Alberta, operates across treaties 4, 5, 6, 7, 8, and 10, not 5 actually, and respects the histories, languages, and cultures of all the First Nations, Métis, Inuit, and other First Nations peoples of Canada, whose presence continues to enrich our vibrant community. The second thing is today we're giving legal information. We're not giving legal advice about anybody's specific problem. Um, okay, there is that. And I also want to acknowledge our funders that made this possible today. We are funded gratefully by the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation. So we're grateful for those things. I want to welcome, my name is Jeff Surtees. I'm a lawyer and the executive director here at the center. And we have a special guest today, Andrew Skeith from Reynolds, Mirth, Richards and Farmer, a law firm here in Edmonton. And Andrew, do you want to tell us a little bit about yourself and your practice?
Sure. Thanks, Jeff. So I am a partner with Reynolds Mirth. We're sort of a full service law firm at Edmonton, which means we do lots of different stuff. I, in particular, do labor and employment law. And then I also practice what's called municipal law, which is where we do stuff for municipal clients.
Perfect. So the format today is I'm going to read out a myth, a common myth that lots of people believe about things that happen in the workplace. And then Andrew is going to talk about why that's true or not true, and maybe give a few examples about things. One thing that I wanted to say before we start, and Andrew can add if he likes, is that we're primarily talking about non-unionized workplaces today. And there may be some crossover, but if you're in a unionized environment, the first thing you should do with respect to any of these myths is have a look at your collective agreement. Would that be fair?
Yes, yes. And I can comment throughout on some of this stuff that matters more than others. So we can talk about that as we go.
Okay, well, let's dive right in, as they say in the podcasting world. Myth number one, your employer needs a reason to fire you, a good reason.
So this, out of all of these myths that we're going to talk about here today, I think this is my favorite because it is the least well understood. The words wrongful dismissal, every person that I talk to, who's not an employment lawyer tends to think that means, well, my employer needs a good reason to fire me. And that's simply not the case. An employer can terminate someone either with cause or without cause. And without cause just means they don't have any reason and they don't need a reason. But if they decide to terminate your employment that way, they do have to provide you with some sort of notice of that termination. Or that can also take the form of pay in lieu of notice, or what most of you are probably familiar with the idea of severance pay. So, no, you don't need a reason to terminate someone's employment.
Okay, administrative things that I forgot to mention at the beginning. The video is going to be posted later on YouTube, so people don't have to take notes and that sort of thing. It'll be up on YouTube within a couple of days, and we're going to try to leave some room at the end for questions. So if you do have a question that you want to put to us, use the Q&A function at the bottom of your Zoom screen rather than the chat function. That being said, okay, on to myth number two. Your employer has to give you benefits.
So, no, there's no obligation for an employer to provide any type of benefits. Health and dental are the typical kind, but we're also talking about pension benefits, RSP matching, some other types of pension things, health spending accounts, all of these kinds of things. There's no statute or law which requires an employer to provide their employees with this kind of stuff. It's become a market reality that an employer is going to have a harder time hiring someone if they're unable to provide those kinds of benefits, right? So that's the reason why employers do it. And often are offering better and more competitive benefits packages. But the Employment Standards Code, and I should add, when people say labor law or the labor code or any of those sorts of things, that's not the right act that you look at to determine what your rights are as a worker in Alberta. You look at what is called the Employment Standards Code. And the Employment Standards Code sets a whole bunch of basic standards, and employers have to meet those standards. But if something is not in the Employment Standards Code, then an employer technically has no obligation to provide it. And the benefits are a good example. They're not in the Employment Standards Code, so an employer does not have to give them to you.
So not even free coffee. That's not even a perk.
No, I've worked in some jobs. Well, coffee is maybe not a great example, but sort of snacks or other kinds of drinks that are things that many pe employers would have in their kitchens. They would have put them behind a vending machine of their own, and they would make their employees pay for them. So, yeah, and they can do that.
I've been waiting for years to do the coffee is not a perk joke. Okay, myth number three, your employer has to give you sick days.
Yes, so they do not have to give you sick days. So there's two kind of related ideas here. Most people think, well, I'm sick. I'm gonna call in to work and tell them that I'm sick today. Usually, that can mean one of two things. It can mean, well, I am a salaried employee and I'm getting paid while I'm sick at home. It could also mean I'm an hourly employee and I didn't show up for my shift because I'm sick and they're still going to pay me for it. But it more commonly is unpaid sick days when basically you just get time away from work because of illness. You're not being paid for it because you didn't work. And so all of these different kind of concepts all generally mean the same thing. But most importantly, the Employment Standards Code doesn't talk about them at all. There's no requirement to provide sick days, whether or not paid or unpaid, under the code. And that's different than some other places in Canada that do actually have paid sick days. Now, there's a related concept called sick leave, and that is something that is provided for under the Employment Standards Code. So what that means is if you need to go away from work for an extended period of time, a week or more due to illness or injury, if you get a doctor's note or a note from a care provider, you provide it to your employer. They have to give you what's called a job protected leave. So if you're on medical leave, the employer cannot terminate your employment and they don't have to pay you anything. It's completely unpaid, but they basically can't terminate you while you're on leave. So that is provided for, but that is different than sick days.
Okay. Myth number four, all workers are entitled to overtime pay.
This is an easy one. Generally speaking, the answer is yes. And overtime pay, I should add, is defined as anything over 8 hours of work in a given day or 44 hours of work in a given week. Um, However, and whichever one's greater as well. So it's not just, if you work over 8 hours, you automatically get overtime. However, there are lots of exceptions to the rule around overtime. So, for example, if you are a supervisor in that you supervise your other employees, or you're a manager, you manage other employees, you don't get overtime. There's also lots of industries where those industries, because of just how those industries work, overtime is not allowed. And well, it's not that it's not allowed, it's not required to be paid. So, you know, one example is actually the legal industry. So nobody who's an articling student or a lawyer is entitled to any amount of overtime pay under the code. And there's lots of different industries that apply.
I've heard of people getting time off in lieu of overtime pay. Is that allowed?
Yes, yes. So you can allow employers can say, hey, you've worked overtime, you're working all this overtime, but instead of just paying you out, because what overtime pay actually is the employer pays the employee 1.5 times the wage rate. So if you're earning $20 an hour, you're now getting $30 an hour for your overtime pay. Um, if my math is correct there. So that's a significant amount of money. So instead of doing that, employers can enter into what are called overtime agreements. And as part of that, you can say, if you work a bunch of overtime, you can basically bank it and take it off as time paid. So you didn't work, but we're still going to pay you for it. So that is a possibility.
Can an employer force you to work overtime? You get to the end of your shift, your 8 hour shift in a bar or wherever you're working, and they say, no, you can't go home yet. We're busy. Can they force you to stay?
Um, so that's a slightly more complex question. I think it comes down to what the generally understood terms and conditions of your employment are. So there's going to be lots of jobs where overtime is expected and required. Um, Ideally, in an ideal world, and this probably doesn't happen very often, when you're hired, the employer tells you that. As a bartender, for sure, it's an industry norm that this is going to happen, right? You're going to be working extra long hours. Overtime is a possibility. Um, and so, yes, if the employer says, yeah, you're expected and required, and yeah, today you need to work some overtime, then you would have to. And if you didn't, if you refused, in those cases, it's open to the employer to essentially discipline you for insubordination. But it depends on the circumstances. If it's a position that is, 8 to 4, 9 to 5, and you never work overtime, and that's very, very unusual, and suddenly you get a requirement. Now you're working overtime today. Um, you could potentially be in a position where you could refuse, but that's a tricky situation.
And with that sort of agreement between an employer and employee, would that normally be in writing or does it have to be in writing?
Well, it should always be in writing. Is it normally? No, almost never probably is that in writing. If you've got a written employment agreement or an offer letter, if it's drafted by a lawyer, it should have something in there about your hours of work, which basically says this requires extended hours. You might be required to work evenings, weekends, out of the ordinary. You may be required to work overtime. But for many people's jobs, it won't say that. Nothing, it won't be in writing.
Right. Okay, on to the next myth. Your employer can take money from your paycheck if you break something on the job.
So the intended answer to this question is no. And that is generally the case. The Employment Standards Code kind of has a number of rules around deductions from earnings. So when you work as an employee, you get paid, whether it's hourly or salary. And the employer can deduct certain things from your earnings. The general rule is they can only do that if the employee agrees in writing to that effect. And employment standards, like the government entity employment standards, they generally view this as being specific permission. So let's say, your employer pays for some training for you, and then you have an agreement that you'll pay the costs of that back over time. That should be a specific agreement relating to that. But otherwise, the employer cannot just say, "Oh, well, we think you might have, cracked a lamp when you were cleaning last night. So guess what? Your paycheck is zero because the lamp was $300." They can't do that. They Now it's interesting because technically there's nothing stopping an employer from suing their employees for property damage. So They just can't deduct it from your wages, which really is a bizarre state of affairs. Because what employer is going to be suing their current employees for money, basically, right? Doesn't happen very often.
Right. You could see it happening if it was something like
Large.
a vehicle or something really big that,
Yeah,
yeah.
exactly.
But
Yeah, that
the waiter who drops your glass in the Cheesecake Cafe, that's not out of his pocket later or her pocket
no,
later.
no, no, no. Of course not. And even like it would be pretty severe property damage. Like not only if they would have to be driving a vehicle and then smash into something and not just damage the vehicle, but some other property and it, all these sorts of things. So there's very narrow circumstances where that would apply. But the general rule is yes, the employer has to get your permission to deduct from your wages, except for overpayments. I'll clarify. So if they pay you too much by accident, they don't need your permission. They can just claw that back on the next pay.
I heard the rules slightly different in the industry if with tips. They
So I looked into this. I don't think that's actually the case.
see, it's another myth, yet another myth we've discovered today.
Well, so not to get too boring, because I know we're kind of touching this at a high level, but the word earnings, well, actually, the word, yeah, sure, the word earnings in the Employment Standards Code includes wages, and wages is defined to include tips or other gratuities. And what it says is you can't deduct from earnings, so that would include wages, which includes tips. So no, I think that if you're earning tips, the intent of the legislation is you still can't deduct from them. But I think, Jeff, that's kind of skirts around the situation where people are not perhaps declaring their tips as income at all. And if they're not being declared, then there's no record. And that, of course, creates a whole nother issue of, well, how do you even, you can't submit an employment standards complaint if I'm not going to claim this as part of my income, right? So that might be where that myth comes from.
Right. And the employer, if it isn't a pooled tip situation, the employer may not even know that you have the tips, so it's nothing for them to deduct it from.
Precisely. It wouldn't be in their control anyway, right?
Right.
So, yeah.
Okay, myth number six. The employer cannot make you pay or can make you pay for your uniform that they require you to wear at work.
Yeah. I actually wasn't familiar with this, but that's true. There is a section which says if an employer provides you with very specific work-related clothing that you must wear for work, the employer has to pay for it. And so it's at the employer's cost. But I think it's you have to be a little bit careful here because I'm thinking of people who work in sort of the restaurant industry. There's generally a requirement to wear black clothing. And you go to whatever retail store you want, you pick out your, black dress shirt or whatever. The employer, that is not what I would call a uniform in the same sense. That's a black shirt. You can wear that black shirt anywhere you want. What this section is getting at is if you go to work at McDonald's and they give you a polo shirt with the McDonald's logo, you're not paying for that. You don't have to pay for that. The restaurant has to.
Okay. Um, Myth number seven. You cannot refuse any work that your employer asks you to do, even if it's unsafe.
Yeah, this is certainly not true. There is an entire other statute called the Occupational Health and Safety Act. The whole point of that legislation is to keep people safe and out of harm's way while they are at work. So there's a number of sections in there actually expressly about refusing unsafe work. And really, what it is if a worker sees that a work environment is unsafe or there's a workplace hazard that hasn't been addressed, the worker is entitled to notify the employer that they are refusing to perform work because of that workplace hazard. That shifts an obligation onto the employer to then, you know, investigate and address the workplace hazard appropriately, and then they're allowed to circle back to the employee and say, okay, we dealt with this. You're required to go back to work. Um, there might be some situations where it's sort of ambiguous as to what is a workplace hazard. And I'll give you a really good example. Um, it's one thing to say, well, I was working on this job site and I found that there was this live wire laying in a pool of water. That's concerning. So now I don't want to work around here. That's obvious. Nobody would deny that that is a workplace hazard. However, the Occupational Health and Safety Act now includes um, such sort of ambiguous terms as bullying and harassment in the workplace. And so that is a workplace hazard. And so technically, if an employee views, there to be some sort of ongoing bullying and harassment that creates a workplace hazard, under the act, they could say, I'm refusing to work because it's unsafe. And then, of course, that triggers a whole complicated state of affairs where the employer has to investigate, but there's a lot of, subjectivity in that sort of a process. So that can create some sticky situations, but certainly from a basic standpoint, if it is unsafe, physically unsafe, you have no obligation to work until that hazard is addressed.
And is it enough to just, I mean, you say an investigation and stuff like that. What does the employee actually do if they encounter a situation that they legitimately feel is unsafe? They just say, I'm not doing that. What
I
happens
mean,
then?
they have to, I think they have to provide notice that they are refusing to work because of an unsafe work environment. Best practice would be to put that notice in writing, obviously. So shoot your boss an email or a text, um, and give specific reasons. You can't just say it's unsafe, I'm not working. It has to be very specific, like there is this going on that creates an unsafe work environment. I can't work there until that's fixed. So that's sort of what the employee has to do. The reason, again, if it's a physical hazard, that's easy. It's really difficult if basically you're saying, well, I think, X, Y, or Z is bullying me and it's an unsafe work environment. Because then you can get into significant legal risk yourself if you suddenly turn around and say, it's an unsafe work environment. I'm not going to work until you address this. You don't necessarily have a right to do that as an employee in those situations. So again, this session is not about any one specific situation. This is legal information. Um, but if you are in a situation where you feel like you are unable to work because of bullying and harassment, it's a good idea to seek legal advice before you do anything.
Right. I do, and I suppose with the written notice to your employer, it's going to, in some situations, that's not going to be possible. I can think of an example that may or may not have been one of my own children who was working doing roofing on a roof, and there was a lightning storm approaching, and the foreman would not let them leave. Said, "No, we have to finish this roof." And my son said, no, there's a storm it's coming right now. I have to get
Yeah.
off the roof and did, but there's no opportunity for written notice in a case like that.
No, and in that case, I don't think it would be required because your boss is
Right,
standing right there. So
right,
written notice is ideal. But in that situation, I mean, the boss is aware of the issue. You're aware of the issue. You're both looking at it. No one can really deny that that was what happened. So yeah, I don't have any concerns about that.
right. And I guess at a deeper level, and it's not really a legal issue, but if you're being required to repeatedly work in unsafe environments, maybe you want to find a different place to work.
That's right. That's
Yeah,
right. And I guess to sort of close off this one, if your employer cannot discipline you or terminate your employment because you refuse to work in an unsafe environment. So
right.
there is a protection for that point as well.
Okay, the next myth is a really interesting one for a lot of people because it applies to so many of us in the modern day. Your employer is allowed to monitor your work computer and your personal devices without telling you.
Yeah, so we can break that down. So work computer. Let's you've got a laptop or you work on a desktop at work, or your employer provides you with one of those devices. Maybe your employer provides you with a cell phone, they pay for it, but you use it for work. So those devices are owned by your employer. It would be the same as if you go out to the store and buy a computer. That's your computer. That computer that you're using for work, it's not yours, it's your employer's. And so the employer does have a right to basically do what it wants with its own property. And that includes installing monitoring software, time tracking software, all these sorts of things which allow employers to keep tabs on people, especially these days when a lot of people are working at least partially remotely. Um, Now, the myth is that they can do it without notifying you in any way. There has to be, all of this is going to privacy issues. And in Alberta, privacy issues are governed by a few different pieces of legislation, the Privacy Information Protection Act, the Access to Information, and there's a different one as well for private sector employers. So those acts basically say that when an employer collects information about from an employee, they can only personal information, they can only do it with their consent. And you can get consent through not just you saying, yes, I agree that you can track my time and know what I'm doing, but when you sign up for when you start working somewhere, that place will have policies. Those policies will say, we have tracking software on our computers. As a condition of working here, you agree to comply with our policies and that you're aware and acknowledge our policies, which say that we're going to track your time and we can make use of that information for discipline or to manage your employment. So they don't need to have sat you down and said, hey, guess what? Here's how all this software works. Here's what everything that is happening on your work devices. They don't need to go that far, but check the policies. There needs to be some sort of notice to employees, and it is usually in a policy or in your employment contract or something like that, that you're going to have been notified. And if they truly don't notify you at all, then that is an issue. It could be a privacy breach. But that's the starting point. And again, right now we're only talking about work-owned devices. Uh, there's lots of case law out there where workers have done something on their work computer that's not so great. Employers have discovered it and made use of it, to discipline, to terminate, or even in criminal proceedings, all these sorts of things. And ultimately, in various areas, the law is pretty clear. You don't really have a right of privacy if that device is owned and is provided by your employer. So a really hot tip to take away is that if you have a workplace device, try to use it for personal, use as little to as possible to never if you can. So don't log into your bank on your work computer. Don't, save your personal information on your work computer. Don't do any of that stuff. You can browse the internet, as, within caution. There's issues with that. But generally speaking, you have to be very cautious about using workplace devices. But Jeff, your question was also personal devices. And
Yes.
personal devices is a very different scenario. So if you have a personal device, the employer does not have the right to that device, provided that you're not using it in any way for work. So that's why it's sometimes there's a careful division there because some people they get a reimbursement from their employer for their cell phone bill for part of it on the understanding that they're using that device for work. That is actually a more ambiguous situation because it's owned by you, but you're using it partially for work. So you do have a much higher right to privacy on that device, but I can think of a numerous situations where you would be required to disclose items or records or call logs or whatever from that cell phone because you were using it in the context of your employment. So, for example, in a lawsuit, um, if you have a phone that was used partially for personal use, partially for work, you're gonna probably have to dig through that phone and disclose records. So you do have to be very, very careful about using personal devices for work. Best practice is just to have a personal device, use it only for personal, and keep your work separate.
Right. Okay, myth number 9. Discrimination only counts if your employer means to discriminate.
Yeah, this is not the case. I mean, intentional discrimination is obvious, although that can be very hard to prove. But there's lots of, indirect or unintentional discrimination. So intention is not part of the test for discrimination. Discrimination, the test is basically whether or not you've suffered a negative impact in your life. So something bad happened to you, whether you have one of the protected grounds under the Alberta Human Rights Act. And so what those are things like, race, ethnicity, gender, sexual orientation, country of origin, all these sorts of things. Medical status, so mental or physical disability. And so you have one of those things, you suffered a negative impact, and the protected ground was actually a factor in the negative impact. So, easiest, most stereotypical example, um, a woman is hired by an employer. The employer learns that she's pregnant and going to go on mat leave, and the employer terminates her employment because of that. That's obvious discrimination, and that's intentional discrimination. But the test doesn't require you to actually prove that there was an intent. It's just that it happened, and you have to prove that negative, that protected ground was a factor in that negative impact.
I've also heard about bona fide occupational requirements. Can you describe what that means?
Yeah, yeah. So there are a number of exceptions. And actually, I think maybe that's even the next myth that we were going to talk about. The employers are never allowed
Oh,
to
I
discriminate.
skipped ahead.
Well, to answer the question that you didn't ask, employers, the next myth we were going to talk about is that employers are never allowed to discriminate. And in fact, technically you are. There are a few circumstances where discrimination is acceptable at law. And it sounds silly or strange, but it actually makes sense when you dig into it. So Jeff just mentioned the one of those instances, which is called a bona fide occupational requirement. So when you have um, a, a condition of performing a job or job duties that is legitimate, that is reasonably required to actually perform that job or those job duties, then that is known as a bona fide occupational requirement. A great example of this is firefighters. Firefighting is obviously a very physically demanding job. And there's a famous fitness test that firefighters will usually have to pass. And that is the fitness test is reasonably connected to the actual job duties because you have to be able to, tote around all that equipment. You have to be able to pull the hose. You have to be able to, you know, meet certain physical tests in order to actually and safely perform that job. So it is a bona fide occupational requirement of being a firefighter, for example, that you pass a fitness test. The famous case on this is a decision called Majorin, um, where a female firefighter candidate challenged the validity of the fitness test. And it was found that, well, this is a bona fide occupational requirement because there is a legitimate reason to actually, have these requirements for this position. So that's one example. So where you can discriminate, but there's a reason for it, right? There's a policy reason behind it. Another example, and it's a broader example, is that there are things called ameliorative action policies. There we go. Where essentially employers will target certain marginalized groups and say, if you belong to this group, we are cherry picking these specific groups or people who identify with these characteristics for these opportunities to the exclusion of others. That's naturally discriminatory. But it's discriminatory for a good reason, right? It's to give marginalized groups who have sort of socioeconomic challenges opportunities that they otherwise would not. And so those kinds of policies are protected under the Human Rights Code as well, Act. Um, and then finally, there's a general power to sort of say, you know, we can discriminate in certain circumstances if it's reasonably necessary and justifiable. And so this one's harder to define because it's sort of a catch-all, but it is sort of an idea. Like one example that came up in my own practice recently was, um, I act for an employer who has an ameliorative action policy, and they practice certain cultural practices within the workplace. And you had someone who was hired at that employer and who would actually go around and criticize these cultural practices as not going far enough because basically this person had sort of more extreme views. And so that person was going around and saying, this isn't the way to do it. This isn't the real way you should be practicing. This is the correct way. And so ultimately the employer had to let that person go because they were being discriminatory towards all the other employees in the environment. And in my view, that's a great example of something where, okay, maybe it is notionally discriminatory to say, we're not doing things your way. We're going to do things our way. But there's a good reason for that, right? And it's to allow that there's a safe space that everyone can practice in a more in an acceptable, safe environment, free of harassment and racism and these sorts of things.
So
So yes,
would those types of policies cover something like, um, an Indigenous organization offering programs for Indigenous people, only hiring Indigenous workers?
that's exactly what they're intended for. Yep.
Okay. If you're going to work at Kentucky Fried Chicken, you have to be from Kentucky, something like that.
I
I don't think
mean,
I don't think
it's
that's true.
novel. It could work, I guess. Well,
Maybe.
maybe,
O-
yeah.
Okay, the next one is myth number 11. Your employer does not have to accommodate your disability.
Yeah, I mean, this gets to the same thing we've been talking about. So, absolutely, employers have a duty to accommodate as part of that human rights process. So, if you have a physical or mental disability, employers, provided that the employer is aware of it, that you make the employer aware of it, and, at that point, that triggers this duty to accommodate of the employer. And the employer has to sort of say, okay, well, what do you need? Like, what do you need from us? Um, and the employee ideally provides sort of medical information, which will support what sort of accommodations you need. And then the employer, they don't have, and I want to be careful here, the employer does not have a duty to accommodate endlessly. It's a duty to accommodate to the point of undue hardship. So, and really what that means in any given circumstance varies. But if it's the kind of thing which is saying, well, look, I have insomnia and mental health issues, I have a hard time getting to work for 8 a.m. Could I have an 8:30 start time? That will help me, and I have a medical note and all these sorts of things. Provided that the employer's operations are such that that's not impossible to accommodate, that's a very reasonable accommodation request. On the other hand, if it's, well, I have a unique sleep disorder, I only sleep between 1 p.m. and 4 p.m. in the afternoon, so I can only work, midnight to 5 a.m. So you shouldn't accommodate me. Well, good luck with that. That's just not the reality for almost any employer, right? And so while you can put that request to an employer, the employer would not have a duty to accommodate that because it would create undue hardship, essentially.
And the undue hardship we're talking about is of the employer, not the employee.
That's right. Yes, yes. So the employer basically is going to suffer some hardship from any form of accommodation because if they didn't, then it's not even necessarily accommodating anything, right? It's just these are normal work circumstances. But they don't have, there's a ceiling to that, right? They can only have an obligation to go to a certain point. So another example is I hurt my back. I was a laborer. I used to work at the warehouse loading trucks. I can't lift anything now above 10 pounds. Okay, well, so, does that allow you to do any kind of labor work? Not really, because all of you, you sell, I don't know, weights, and all the weights are 40 plus pounds or something. Well, that's not going to work for me. So then the employer has to go look at their organization and say, are there any other jobs we can, indefinitely provide for this person? And if there aren't, and if the person isn't trained or qualified, in most cases, that will be where it ends, right? Provided that this isn't just a temporary thing. They might have an obligation to provide temporary work coverage, but not certainly not indefinitely pay someone who's injured, basically, or pay them to sit around and count paperweights or something like that.
Right.
That's not what the duty to accommodate is for.
So that the hardship could be operational or it could be financial. It could be
That's right.
any number of things.
It could be any number of things, and it is difficult. Some employers take the view that as soon as I have to spend a dime more than I normally would, that's undue hardship. That's not often the case.
Right.
That is, in fact, almost never the case. Some small financial or some financial burden might be acceptable. It's when in your specific circumstances does it become, unreasonable or undue. And hard to give specifics.
Okay. Myth number 12. Your employer can fire you if you make a complaint.
So we've kind of talked about this a little bit. So we mentioned occupational health and safety. If you make a complaint under that act, you are protected from retaliation, so they cannot terminate you. And if they do, you're entitled to be reinstated. Similarly, under the Employment Standards Code, um, if you go on a protected leave or you make a complaint, usually if you're making an employment standards complaint, you've already been fired. So that's kind of not the usual course. But there are protections there as well. Excuse me. The Alberta Human Rights Act does have specific protections for what's called retaliation. I'm just gonna have a sip of water here. And so if you submit a human rights complaint and you're fired or disciplined or whatever, and again, this presumes you're actually still working for the employer, then you have the ability to submit another human rights complaint for retaliation, which can result in further, monetary damages and penalties against the employer. But those kinds of complaints, you are protected. But just, complaining about something in the workplace, some people think, well, I've witnessed something, I've witnessed some shady business, or I saw someone bullying someone. I'm a whistleblower. I must have some magical protection. No, you don't necessarily. Excuse me. So in those situations, you actually do have to be careful because many times if it's something that you're complaining about or you submit a complaint about and the employer isn't fully on board with it, you could end up being disciplined. Not that I'm saying this is the right thing for an employer to do, it's the wrong thing, but it has happened. And that is much more difficult to address because you can't just complain to employment standards about it.
Right. Thank you. Uh, Myth number 13. An employment contract can take away your basic rights.
So, it depends what we mean when we say basic rights. So, we've talked about you have sort of basic rights that are guaranteed under the Employment Standards Code, like right to overtime pay, right to certain times, hours of work, all these sorts of things. You can't contract out of that. So, if you have an employment agreement and the employer has written in there, you are not going to get any overtime no matter how many hours you work. That's not correct. That provision in that contract would just not have any legal effect because essentially there's a portion of the code which says you can't contract out of these minimum standards. Um, but employment contracts do allow employers to take away all sorts of rights from employees, and that's part of freedom to contract, right? That's why it's important when you do get an employment agreement to, depending on the circumstances, to get it reviewed if you think it's necessary by a lawyer to ensure that, your rights are you're at least content with the agreement that you're entering into before you start work.
Right. Okay, the last one, myth number 14. Only Canadian citizens have worker rights.
This is not true. So, if you're working here, you are subject to the Employment Standards Code. So if you're working in Alberta, your employer still has to provide, you a safe workplace. They still have to pay you overtime and do all those things in accordance with the code. So it's irrelevant if you're a Canadian citizen or not.
Perfect. Thank you very much, Andrew. We've got a couple of questions in the chat. If anybody has any last minute ones, feel free to throw them in there. I'll just read them out here. The first one, if I'm not this is the listener's statement. If I'm not mistaken, maybe a few years ago, the province changed the overtime mandatory pay and must work rules in the oil and gas field, perhaps forcing the banking of overtime as straight time or smoothing of overtime over 2 weeks. Yes or no? That's a pretty specific question for a pretty specific industry. So if you know, Andrew, I'll put it to you, and if not, we can leave it.
You know what? Let's come back to that. I'm trying to look up the answer quickly as we talk, but let's maybe do the next one.
Okay. Um, the next question is really just a suggestion from a listener, but it seems like it's a good suggestion. Pro tip, personal cell phone apps for clocking in and out uh, or a safety form can be very invasive beyond their stated purpose. If you hate this, just use a dumb mobile phone rather than a smartphone for work. So that's probably an okay suggestion. And the last question we have in the chat, and this is interesting, if an employer cannot accommodate a worker on the basis of uh, undue hardship to the employer, is that a termination of the worker with or without cause?
Um, Okay, that's not as easy an answer to give as you might think. So,
Yeah.
um, it really depends a lot in that circumstance. So, what you might see, is, a worker who's got a disability, let's say, that's the easiest example. They've got some accommodation requirements. Let's go back to sort of a physical disability situation. Um, if they can't do the job anymore and the employers looked around and they just can't accommodate them, at that point, usually the employer will be obligated to simply terminate without cause. It's certainly not with cause. There's no misconduct on the part of the employee because they got hurt, right? So you didn't do anything wrong. Without cause would be the typical situation where you'd say, well, unfortunately, we don't have any work for you, so we're going to have to let you go. Now, there are related situations, though, where someone can become disabled. And if they become permanently disabled, to a degree that they are unable to basically perform any work for the employer, that doesn't result in a termination. That results in what's called contractual frustration, where the contract just fizzles out of existence because basically it becomes impossible to perform because the person is permanently disabled based on medical evidence. So that's a different situation, but it also happens, but really only in the context of medical disability.
Great. Thank you very much. That's a great answer. That it takes us to the end of the questions. I want to thank Andrew very much for helping us today with this and answering. We've got all kinds of employment resources and resources about many areas of the law available on the CPLEA website here at CPLEA World Headquarters. We've got a booklet called Workers' Rights 101. You can read that online, and there will be links in the chat for these things, or you can order a copy from us and we'll mail it out to you at no cost. We've got all kinds of resources about your rights at work on our website, and so feel free to have a look at those. Today's webinar, as I mentioned at the beginning, will be available on our YouTube channel in a few days, and anyone who participated today and gave us their email address will get a link emailed back to you. You can join us for our next webinar in March, which is called Renting Reality, Busting Legal Myths About Landlords and Tenants, and that's always a very popular one. You can stay in touch with us here at CPLEA by visiting our website and subscribing to our monthly newsletter, or following us on a couple of different social media platforms at CPLE Alberta, just one A in there. You can connect with Andrew. His contact information, if you need legal advice about these matters, his contact info will be posted in the chat as well. And please, 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 everybody hates surveys these days. We're surveyed to death, but it's really important to our funders that we get feedback from our users about how you think we're doing with some of this stuff. And with that, we'll call it to a close. Thanks everybody for participating today.
Thanks for having me, Jeff.